Ever wondered why your neighbor can walk across your garden? Or why you can drive through someone else's land to reach your home? Welcome to the fascinating world of legal easements in English land law. Hello and welcome to Blackstone Solicitors YouTube channel. And today we're diving into one of the most misunderstood but incredibly important concepts in property law, easements. An easement is a legal right to use someone else's land for a specific purpose. Think of it as a right of way, but it can also include rights to light, drainage, or even parking. To qualify as a legal easement, 4 key conditions must be met, set out in the famous case of Re Ellenborough Park, 1956. 1. There must be a dominant and servient tenement, 2 separate pieces of land. 2. The easement must accommodate the dominant tenement. It must benefit the land, not just the landowner. 3. The dominant and servient owners must be different people. And 4. It must be capable of forming the subject matter of a grant, meaning it must be clear, certain, and not too vague. So, some of the most common easements include things like rights of way, which, allow people to walk or drive across someone else's land. Then there are rights of light, basically making sure your windows aren't blocked by your neighbor. There are also rights of drainage or water, which let pipes run through neighboring land. And of course, parking rights. Though honestly, these can be a bit tricky. Parking easements have actually sparked quite a few legal debates, especially when it comes to something called the ouster principle, which in simple terms means an easement can't give someone exclusive possession of land. In the case of Batchelor v. Marlowe, the court decided that parking rights which completely exclude the landowner might not actually count as easements. Easements? Well, they can arise in several different ways. First, there's an express grant, which is written into a deed. Second, there's an implied grant, which is kind of inferred from the circumstances. Third, you've got prescription, where someone's had long use for over 20 years. And finally, there's necessity, which comes into play when land would be unusable without the easement. So if you buy a landlocked plot, the law may actually imply a right of way over neighboring land to access it. So, can easements be lost or challenged? Yes, absolutely. Easements can actually be extinguished if they're not used, if the dominant and servient land come under the same ownership, or if the use radically changes, as seen in McAdams Homes versus Robinson. Whether you're buying, selling, or developing property, easements can really affect value, access, and your legal rights. That's why, honestly, it's crucial to get expert advice. At Blackstone Solicitors, we specialize in property law and can help you navigate easements with confidence. Contact us today for tailored legal advice. Thanks so much for watching. Don't forget to like, subscribe, and hit the bell for more legal insights from Blackstone Solicitors.